Again, Mr. and Ms. Turner, I want to thank you for coming in today to discuss the various aspects of your financial position and go over this financial plan. I know one of the more important pieces of the plan that we had talked about was the estate planning piece. I know you guys had some current concerns around the various aspects of estate planning, with like a full assessment of your deficiencies around estate planning and an explanation of why each one of those deficiencies may be important to you and your family. Also, you guys said you wanted to look at getting a better understanding of the probate process and what current probate totals would be for your assets that would pass through probate. So we'll take a look at that. We also decided we would discuss the beneficiary election on the life insurance and IRA accounts. That way we can kind of get an idea if that's the best way to have those set up as far as your beneficiary election goes. But let's start by talking about the probate process. Probate is a state-adopted method of transferring ownership of assets from a decedent to that decedent's heirs at death. Okay, this process can be necessary if a person dies with a will, which is called dying testate, or dying without a will, which is dying intestate. When a person dies without a will, state law determines the disposal of that person's assets. These laws can vary from state to state and may not reflect the deceased individual's wishes. So you can see just from that piece alone how important it might be to have a will in place. So generally, assets that are subject to probate fall into one of four categories. Assets individually owned by the decedent, property held concurrently with another with no survivorship rights being present. The decedent has 1/2 interest in community property or assets that pass to a decedent's estate at death, such as a life insurance policy that has the estate labeled as the beneficiary. So in this case, Alan, I wanted to go over your assets first that would go through probate, and then Elsie will go over your assets that will be subject to probate second. So Alan, we've got the insurance policy B of $75,000, the First Growth Mutual Fund of $7,950, the brokerage account for about $100,000, your truck for about $32,000, and then your boat for about $10,000, which would put your total at $224,950. And Elsie, in your case, we would be looking at the investment portfolio of about $210,000. The education fund of $22,747, your car, which is about $21,000, and then the furs and jewelry, which are about $10,000, bringing that total up to $263,474. So that kind of gives you an idea of the probate process and which portion of your assets would be subject to that process. The next issue we wanted to address were the planning deficiencies and why each one of these issues might be important to you and your family. So the first thing I want to discuss is the lack of a will. The will, of course, is the legal document that will allow the testator to transfer property at the testator's death in the manner desired. This will also allow for an executor to be named, administrator of the estate, to designate a guardian to take care of minor children. This is where Sarah could be named as that guardian. I know you guys talked about her taking care of the kids if something ever happened to you. Well, this is where we would go from talking about that to actually writing that down and making it legal. Designate personal or real property to pass to certain individuals, and the ability to effect transfer tax planning through the use of certain legal interest or trust. Also, the lack of a durable power of attorney for health care. This is a power of attorney document that one sets up, and you designate a power of attorney, usually one's spouse, to make crucial health care decisions on your behalf in the event that you become incapacitated and cannot make those decisions yourself. Something similar to that I think would also be important is a living will. This is a document that would allow a person to go ahead and make a decision if they would or would not want to receive life support if death was imminent. If you had were in a coma, for example, and there was no chance of you coming out of the coma, do you want life support, being hooked up to a breathing machine or feeding tubes, things such as that. You can go ahead and make that decision with the living will. Also, I would recommend looking at letters of personal instruction. Now, this would be used to notify the representative of your estate as to the particular instructions of your funeral arrangements and the location of important documents, and also various other items could be included in this letter. The reason for this letter is this is typically read before the funeral, as the will is typically read after the funeral. So this would give whoever's handling your affairs kind of a jump start on getting things going as far as your estate goes. Also, I think it'd be important to have a discussion around the potential use of trust in your estate planning. It would be important to work with an attorney to discuss the potential benefits of using a trust in your estate planning process. But based on the fact that part of your assets in your financial plan are dedicated to education, possibly a Section 2503 trust, which is an education trust, might be appropriate. Or a support trust for minor children, since you do have 3 minor children in your family. Again, this is a conversation that needs to be had with an attorney who specializes with work in the trust field. So, the last thing that we said we wanted to talk about were the beneficiary elections on your IRA and your life insurance policies. As far as these current beneficiary elections, I would consider changing all of the beneficiary elections to each other. On the insurance and retirement accounts, unless you have a specific account that was earmarked for a certain individual. Like if you wanted a life insurance policy to just go to the children, you could just keep the beneficiaries as the children on that, for example. But I would also consider adding transfer on death titling to all individually owned accounts to avoid the probate process on these assets. So if something were to happen to one of you guys, it would go to the other without having to go through the probate process. I would then, when you talk to the attorney about the potential of using a trust, I would also discuss with that attorney if it would be advantageous to use a trust as the contingent beneficiary on some of these assets. So if something happened to both you guys simultaneously, for example, that these assets would potentially go straight into the trust. So that kind of gives you an idea around the beneficiary election side of things. Do you have any questions regarding estate planning in your particular situation?